wholly owned subsidiaries, set up joint ventures, strategic partnerships, whether it's a joint development partnership or distributorships or value-added resellers. Mergers and acquisitions is another way of going global, acquiring companies in other countries. And then another method is to go direct to foreign consumers. I see a lot of that in the US. US companies go to the European Union looking for consumers for their medical devices. It's a little bit easier. I shouldn't say too easy, but it's a little bit easier getting medical devices approved in the European Union when compared to the US under the FDA. Cross-border transactional challenges. There are a lot of challenges. When you are involved in a domestic transaction, you are very focused on the contract, your domestic laws, your IP laws, but when you get into the cross-border space, there are new pieces that are thrown into the mix. The national laws of your partner, international treaties, and then who is going to be the customer, or is it going to be IP development? A lot of issues. Today, what I will not be talking about, but I did want to give you a heads up on, are some of the other transactional challenges involved in going global. There are tax consequences. There are transfer pricing issues. There are foreign governmental approvals and permits. This is very true when companies from outside India want to invest in India, as an example. There are foreign filing requirements. Again here, a lot of government oversight in India over license royalties, as an example. Compliance with foreign laws, including warranty limitations, consumer protection, the Foreign Corrupt Practices Act, and anti-bribery laws. There are consumer warranties which are required to be much longer in the European Union than compared to the US when it comes to consumer products. Consumer protection exceedingly tight in the European Union, less so in India, and quite tight in the US as well. Foreign Corrupt Practices Act and the UK's anti-bribery laws, when companies are coming out of into India, they're all concerned about these anti-bribery and the Foreign Corrupt Practices Act because they have extraterritorial jurisdiction, and you can get fined in your home country for any corrupt practices in a foreign jurisdiction. And then there's hedging for foreign exchange risks, just from the difference in the exchange rate and what you promise to pay or what you've been promised to receive as payment. So these are a lot of the very significant cross-border transactional challenges. Again, just wanted to give you just a heads up on them. I will not be speaking to them today. Today's focus is cross-border licensing issues, because this is a forum for intellectual property. I will be speaking to intellectual property related due diligence, protection of intellectual property in the cross-border context, some examples of weakened license restrictions and enforceability issues, international IP dispute resolution in the context of contractual relationships, and choice of law. IP-related due diligence, in addition to other due diligence, is really important in a cross-border context. Due diligence is critical for global transactions. Cross-border IP due diligence questions that you should be asking about, whether you are an Indian company going into the US, the EU, or any other jurisdiction, or it is a US company coming to do business in India. These are questions which are relevant wherever you are when you're doing cross-border transactions. Number one, if you're a licensee, does the licensor actually own the IP? And by that, I mean not just that a group, in general, one of the companies in the group owns the IP, but rather find out whether the party that you are going to be contracting with owns the IP. If that party does not own the IP, find out who in the group companies actually holds that IP, and see how the assets are distributed between the companies. If something goes wrong and you find yourself in a situation where you need to enforce the license, you need to find out which is the entity that actually owns the IP. Does the licensee have any strikes against it? This is obviously a very important question for any owners of IP. Can the licensee be trusted? What specific intellectual property rights will need to be licensed? Not every company will give you rights to its patents. A lot of US software giants will give you rights under their copyrights and trade secrets, even know-how, but they may not include a patent license. Which licensee affiliates will need the license? That is an important question because you want to make sure that if you're licensing in IP, you ensure that the scope of the license covers your affiliates who will need to be able to use that intellectual property. At the same time, from the licensor's perspective, you want to be really careful about where are these affiliates located. Can I export my software into those jurisdictions? How strong is the IP protection regimen in those locations where those affiliates are located? Do I need to protect my IP and say there are only certain kinds of access that are permitted to those affiliates? So be very careful about agreements where all these affiliates are lumped into the licensor or the licensee category. You want to make sure that the contracting parties are specific entities, and then you want to make sure who is actually going to touch that IP from the licensee side. In which countries are licensors and licensees' assets predominantly located? This is a very important piece, actually, because when it comes time to collect damages on a breach of contract, or when it comes time to enforce your rights under the contract, you want to be able to actually go after an entity which is not just a shell. You want to be able to attach assets. Otherwise, you will find that the other party to the contract is not taking its obligations on seriously. Will any of the IP assets to be licensed infringe a third party's intellectual property rights in the foreign jurisdiction? So, this is actually very important from the licensor side. As a licensor, you have been in your domestic market, you've got domestic patent rights, domestic trademark rights. Now you decide, I want to expand into another jurisdiction. Say you're coming to the US. Now you need to investigate. Are there patents over there that I might infringe or my distributor might infringe? Are there trademark rights there that are already existing and therefore I cannot use the same trademark for my products in that jurisdiction? These are very important concerns, and when you talk to foreign counsel, that is essentially the counsel in the jurisdiction where you're going to be marketing your products or seeking partnerships, they will be able to guide you and tell you what is the real chance of continuing to rely on your existing intellectual property, what steps you might need to do to get into that market from an IP perspective. The second aspect, the second side I want to talk about is protection of intellectual property. This, of course, is very important for owners. Register your key export-related IP assets, such as patents and trademarks, in the licensee markets. The last thing you want to find yourself is in a situation where the licensee goes and registers a trademark. And it has happened in a lot of jurisdictions. And it's a problem where the unraveling is a painful process. Because the licensee sometimes thinks, well, they've invested so much time into the product, and therefore they should own the trademark in that jurisdiction. And that's not how it works, obviously. Tailor intellectual property agreements and clauses to overcome or work around presumptions under foreign law. I can't begin to tell you how important this is. In the US context, where US licensors, where US companies purchase software and have software developed from India. One of the key things that a lot of US contracts do not adequately cover are the presumptions under the Indian Copyright Act. Under the Indian Copyright Act, and to make that clear, the intellectual property arises in the jurisdiction where it's created, and notwithstanding whatever is the choice of law of the contract. So when an Indian software engineer creates intellectual property, then it's the Indian laws that would apply to who would own that IP. Definitely an assignment is included in most of these US contracts. But the focus stops about there. What you want to focus about is, what does the Indian copyright law say? And there are presumptions under the Indian copyright law, one of them being if the assignment doesn't specify that it's worldwide, then the assignment is limited to the Indian territory. Another presumption is that if you don't exercise the assigned IP within a specified period of time, the assignment reverts. Now, these are all well and good presumptions instituted by the legislature in India for specific reasons. But as a foreign company, which is getting software developed from India as an example, it is actually very critical that they cover those presumptions or override them in the contract, or they address them through some sort of a license. That needs to be done. And that's true when, for Indian companies, developing software or going and licensing their intellectual property in other countries. Because every country has its own IP laws. They're pretty uniform, but there are, caveats and deviations that you need to take into account, and you do that by consulting with foreign counsel who are specialized in intellectual property rights. Require the licensee, including joint venture companies. Remember, in a joint venture, you have almost three parties, right? The two companies investing into the joint venture, and then the new entity, the joint venture company. So there are a lot of times where in cross-border transactions involving joint ventures, the parties forget or omit putting some constraints and restrictions around the license and license scope on the joint venture company. So include the joint venture company as well. But what kind of restrictions? One, no contest terms. You don't want the joint venture company turning around, and this could be even in a distribution relationship. You don't want your distributor turning around and challenging your ownership of your intellectual property. You certainly don't want that, and that should be a cause for immediate termination of the relationship. That is how you would control the intellectual property. Confidentiality obligations. Include those, because there are many jurisdictions, including India, which does not, while there's the Official Secrets Act, there is no Confidential Information Protection Act, or so to say, for private parties. It is all governed by precedent through courts. That's well and good, but it's always better to include confidentiality obligations in the contract. And then, as far as IP is concerned, include a present assignment and cascading licenses and waivers of any rights to your intellectual property which may vest in the licensee by virtue of the transaction or the activities performed, including rights in derivatives and improvements. And I say not just a present assignment, but also a cascading license and waiver, which is essentially, in addition to the assignment, you say, if as a matter of law, you cannot assign this intellectual property back to the licensor, then you hereby grant me a perpetual, irrevocable, worldwide, royalty-free, fully paid license to do whatever I want, and without seeking your permission or paying you anything further on that IP. And then include further a waiver. A waiver is very important with respect to certain rights which are not technically intellectual property rights. Those are the moral rights or the special rights, where an engineer, for example, can claim paternity, or essentially the right to be recognized as the person who created the software and have his name listed on it. Moral rights are not recognized in the US, but they are well and good in many countries, including India. So you want to have a cascading license. Some examples of weakened license restrictions and enforceability issues. So this is really going more to, in cross-border transactions, you have to accept that under national laws, you are going to have to give up certain rights to a certain extent or deal with it in a different way. But you may not be able to license your intellectual property and expect the same level of license restrictions, such as having exclusive distributorship as a condition for exercising your IP and selling your products. But to start with, US copyright law and the European Union Computer Programs Directive permits reverse engineering of computer programs for achieving interoperability. In the US, however, contractual restrictions on reverse engineering have been upheld, so they are enforceable. In the European Union, on the other hand, contractual restrictions on reverse engineering are not enforceable. The good news, of course, is in the European Union, once you do reverse engineer the computer program, you can't create a competing product, and you can't disclose the source code. But nevertheless, if I am the owner of the software, I would think, well, interoperability is important, and if the licensees didn't end up doing the whole reverse engineering on their part, maybe I could have created a strategic partnership with the other computer software owners to create an interoperability and plugins and all of that thing, and derive revenue from that. So it is a real issue for software licensors. Under German law, sub-license agreements are protected even though the license agreement is terminated for any reason. So in one situation, the licensee did not pay license fees to the licensor, but and the licensor called a breach, obviously, and terminated the license. But during the period that the contract was alive, the licensee had granted sub-license agreements, and the court held that those sub-license agreements would continue. Of course, the court expects the sub-licensees to pay license fees to the licensor, but you now have a direct relationship with all of these other sub-licensees, and it's much easier to just collect the fees from one licensee. And so if there's any license fee breach, then those are issues. Japanese courts have reinstated licenses to distributors, notwithstanding a termination that is in accordance with the agreement. So even if the agreement provides for a termination at will, Japanese courts require, if the distributor has expended significant investment, that the distribution agreement continues. So that is a unique thing, and there are ways to deal with it in the contract. But it's something that you want to go in with open eyes when you go into the Japanese market. Competition and antitrust laws impact restrictions, including restrictions on distribution and pricing on distributors in many, many countries, including India and the US, but particularly in the European Union. Under US law, unless a licensee elects under Section 365N of the US Bankruptcy Code to retain rights to in-licensed intellectual property within the prescribed time and continues to pay royalties, the bankrupt licensor or its trustee may reject the license agreement. And that's a very important one. Now, if you are a licensee and you've paid millions of dollars, and your only recourse would be to seek, breach of contract and money damages. And seeking money damages from a bankrupt entity, you're not going to get much. But more importantly on that point, a lot of countries do not have a similar provision where you can, as a licensee, elect to retain those rights. It isn't clear what happens in such a situation in other countries. And that's an area that's still evolving. And I end up talking in a lot of cross-border transactions where I represent licensees. I talk a lot with the Foreign Counsel with respect to bankruptcy issues. What happens to the license, when the licensor goes bankrupt? What kind of recourse I have? And the answers have not always been very clear. Under Indian law, failure to pay stamp duty may make the IP agreement inadmissible in court or other proceedings. So that's an important piece. Any sort of conveyance, license, or assignment of intellectual property, you have to pay a certain stamp duty to the particular state where either the service was performed or the contract was executed. And that is something, obviously, when you are going into litigation proceedings or arbitration, it is something that can be brought up as an issue by the defendant. International IP dispute resolution. In cross-border transactions involving IP and technology, subject to certain exceptions, arbitration is a better dispute resolution mechanism. And the reason mainly for that is that going through litigation through a national court and getting an award from a court is not automatically enforceable in the national courts of the breaching party. The other reason International litigation management can be very costly and subject to delays, uncertainty, and sometimes protectionist foreign courts. And this does happen a lot for licensors from all over the world when they enter certain protectionist markets. The New York Convention on the Recognition and Enforcement of Foreign Arbitral Awards is the good news in this whole story. Subject to limited exceptions, it requires signatories to the convention to give effect to private agreements to arbitrate and to enforce those arbitration awards made in the contracting states. The only exceptions that the New York Convention provides are a limited set of exceptions, and some of those exceptions include if the subject matter is not arbitrable. So in some countries, patent validity is not arbitrable. The award contravenes public policy. 148 contracting states, including India and the US. So in many contracts, obviously between India and US, there are arbitration provisions. Keep in mind, though, that leaves 47 countries who are not parties to the New York Convention. Taiwan is one, and obviously, as you may know, there are a lot of deals that are done with Taiwan. They have very good domestic arbitration schemes, so that helps.